there are some matters that you address here beyond the issues that were discussed before. Is there anything that you'd like to add to your submissions, either in light of what you've heard here today already or otherwise?
Yes, Your Honor, thank you. I did make an argument regarding freedom of association that was not made in the crude brief, or I'm not sure if it was made in any other briefs, that requiring this non-organization to obtain a permit violates the First Amendment right of freedom not to associate. That this is a disorganized event, and people just do just show up not knowing who else will be there, and there is no way effectively for that non-organization to obtain a permit in the way that the state requires. I think Attorney Olson covered some of my concerns with someone who would show up not knowing how many other people are going to be there, and being required to assume liability for anyone else who might be there, and requiring someone to do that and to obtain a permit in the manner that the state does require, and going to the Capitol Police website, that's what one would find is required, violates their right to be free from association with other people who they might choose not to associate. And I cited to Boy Scouts v. Dale, and the right to associate also includes the freedom not to associate with others. Especially when you come to the question of spectators, I think that's an interesting question. The section of the administrative code they seek to change Ms. Mattioni's citation to involves a group, being part of a group and failing to withdraw after an unlawful assembly is declared, and it also applies to spectators. So if people from the Bad River Band were to come down and engage in First Amendment activity that would involve drumming, for instance, there would likely be a large number of spectators that would push the number over 20 and submit everyone to arrest, and people who come and watch something that's going on have even less connection with the group that's performing the First Amendment activity than the people who are participating, but they're swept in under 2.14 sub 2 VM5 to the group that's actually participating. So someone who's considering engaging in protected speech really cannot tell whether they're likely to be arrested, and that was exactly why Michael Kissick filed the federal case, is that he sought to participate, to come and sing in the Capitol. He could not risk arrest because of his professional position at the university, and he had no way of telling. He sought to find out from the police whether he could be arrested, and they told him that anyone, well, it's in the record, but he was subject to arrest. They couldn't tell him how he could avoid arrest, so he brought the federal case against the Department of Administration. Other than that, I have the motion to strike the amendment. Mine is pretty similar to what Attorney Loeb described, although in my case, my client actually did file a plea prior to this technical change being made. She received a letter, which is attached as an exhibit to the state's response brief, informing her that a technical change was being made. And when I looked up technical in the dictionary, it's following the rules strictly, and this was anything but following any rules strictly. But she then entered a not guilty plea to the original citation that she was handed on July 26th, and then received a notice that her citation was being changed. So I think that's even more of a deprivation of due process and deprives the state of jurisdiction, though quite honestly I would rather have these all thrown out on constitutional grounds. I think the state's attempt to make a motion as part of the brief is improper under the rules of civil procedure that they seek to employ here, because Section 801 of the Wisconsin statute says you've got to put, if you're making a motion, it's got to be in the caption. You've got to let the other party know that you're making a motion, and no motion was ever actually made until the state filed its brief well, it was almost 5 months after she was cited. The last thing I was just going to say is that in their First Amendment response, they're claiming that Judge Conley's ruling severed provisions of the code and allowed the rest to remain and basically cured the problems that he found in the administrative rules. And injunctions in federal court just don't do that. They can't do that. And I cited to a case that indicated the very strict and precise limits under the federal rules for a federal court injunction. So, you know, free speech is at the heart of our democracy. That's why we're here today. I don't think the rules are constitutional. I don't think the state has followed the proper procedure in bringing these cases, and they should be dismissed.
Thank you, Ms. Hammel. Just one thing on your point about the spectators. I think Judge Conley did address that in a different discussion than the one that Mr. Crude is raising, and that's the overall overbreadth and vagueness issue. And he did say, it seems like he answered this question about what about, as he calls it, the curious tourist who's mistakenly identified as an event participant. He says, well, that's doesn't rise to constitutional violation because there is the out in the rule in VM that only allows for punishment after somebody, after the announcement's been made that this is an unlawful gathering and is subject to penalties. If a spectator just unwittingly gets caught up in this, that announcement gives that person an opportunity to just leave. Does that solve the problem as far as you're concerned?
No, I don't think it does, because what the rules are chilling is not only the expressive activity, but to that extent, it's even just scaring people off from coming to the Capitol. Just the threat of arrest for engaging in entering the Capitol, observing First Amendment activity, appearing, I think is excessive. This is not narrowly tailored to achieve a legitimate state objective. What is the harm of someone observing a rally or an event or something that's going on in the Capitol? What purpose does it serve to be arresting spectators? The fact that they might be given a warning, I'm assuming that some of those spectators are just not going to come back to the Capitol.
And what about that point, Ms. Weiss? Isn't part of the First Amendment, look at getting back to the underlying purposes, we have a government of the people, by the people, for the people. We are a self-governing people. Part of that is speaking, part of that is listening. So we have somebody who happens to be at the Capitol, has nothing to do with a group that is singing, but is interested in learning and listening and thinks that this is something they want to know more about, and they want to stay there. And I guess they become part of an assembly, but isn't that really what an assembly is? It's a group that gathers, and there can be an exchange of ideas, there can be an expression of ideas to the government, among themselves, whatever it might be. But doesn't this go too far if it brings in somebody who happens to wander by, think it's interesting, wants to listen, is behaving themselves? Doesn't this, contrary to perhaps even the implication that Judge Conley reaches here in a somewhat different context, doesn't this maybe go too far?
Your Honor, I believe that issue is addressed in the written submissions provided to the court by the state, especially when taking note, I think it was pages 29 through 36 of the state's submission. Similar to, for a really short answer to what the court just requested, I would prefer or defer to the Conley decision with regard to the curious spectator, and that when there is a notification that an assembly is unlawful, that person may choose then not to become part of that assembly. If that person chooses to remain part of that assembly, that is the choice that that person has made.
Okay, thank you, Ms. Weezy. Ms. Hammel, anything further then?
No, Your Honor.
Okay, well, thank you very much for the very thorough briefing by both sides in this case. And I also will have a decision in your case within the next 30 days as well.
Thank you, Your Honor.
And you may certainly be seated. We have the McClurg matter with Attorney Aquino then.